Well, welcome everyone to the American Enterprise Institute's panel on how can Congress act constructively on antitrust. I'm Mark Jamison. I'm a non-resident senior fellow with the American Enterprise Institute, and I'm here with a distinguished panel. And I'll introduce them in just a moment, but first, let me lay some groundwork. There was a time when the path to success in big tech company was to be a great engineer. Now it seems that great antitrust attorneys and lobbyists are becoming perhaps more valuable than the engineers. In 2010, for election cycle, for example, Amazon, Apple, Facebook, now called Meta, and Alphabet spent a little bit under $20 million lobbying Congress. But for the last election cycle, 2020, that was nearly $150 million. So it's gone up, and for good reason. There are a number of bills targeting the business models and the competitive strategies of big tech companies. They're gaining bipartisan momentum in Congress. And a lot of people have some concerns about how big tech acts, and some people think that maybe the legislation just goes too far. So that's what we'd like to talk about today. What can Congress really do that would be constructive and help us have more success in the tech industry? So I'm with 5 distinguished panelists. So let me introduce them, then we'll jump right into it. Our first panelist is Michael Kadish. He's the Director for Markets and Competition Policy at the Washington Center for Equitable Growth. His research focuses on competition and antitrust enforcement with an emphasis on consumers, wages, equality, and innovation. He previously worked as an antitrust counsel for Senator Amy Klobuchar from Minnesota, where he led efforts to reform antitrust laws. Previously, he spent 20 years investigating and litigating some of the most significant antitrust actions in the past century as an attorney at the Federal Trade Commission. Michael's a graduate of Yale University and the University of Wisconsin Law School. We also have Andrea Marino. She's an antitrust and competition partner for the law firm of Kirkland & Ellis. Her primary focus is securing clearances for proposed transactions from the antitrust division of the Department of Justice, the Federal Trade Commission, state attorneys general, and international competition law enforcement agencies. She was previously an attorney advisor to a former FTC chairman and commissioner, and served as counsel for 2 attorneys general for antitrust at the Department of Justice. She's a graduate of American University and George Washington University Law School. Maureen Olhausen chairs the Global Antitrust and Competition Practice at Baker Botts, where she focuses on antitrust, privacy, data security, and consumer protection. She most recently led Federal Trade Commission as acting chair and commissioner, where she directed all aspects of the FTC's antitrust work and led U.S. delegations at international antitrust and data privacy meetings. Prior to her role as commissioner, she led the FTC's Internet Access Task Force. She's a graduate of the University of Virginia and has a law degree from George Mason University. Also with us is Nancy Rose. She's the Charles P. Kingelberger Professor of Applied Economics at MIT, where her research and teaching focuses on industrial organization, competition policy, and the economics of regulation. She served as Deputy Assistant Attorney General for Economic Analysis in the Department of Justice's Antitrust Division from 2014 to 2016, and directed the National Bureau of Economic Research's program on industrial organization from 1991 to 2014. She's a graduate of Harvard University and received her PhD from MIT. Scott Walston is president and senior fellow at the Technology Policy Institute. An economist by training, Scott has deep expertise in industrial organization and public policy, and his research focuses on competition, regulation, telecommunications, the economics of digitization, and technology policy. He was previously the economics director of the Federal Communications Commission's National Broadband Plan, and is an economist at the World Bank and the White House's Council of Economic Advisors, and a resident fellow here at AEI. Scott received his undergraduate degree from Washington University in St. Louis and his PhD in economics from Stanford University. So everyone, welcome. Very glad that you're here. So let me just start out. And Michael, I'll direct the first question to you. What appear to be Congress's concerns about competition in tech, and how do these concerns differ between Democrats and Republicans?
Thank you. And thank you, AEI, for having me on this panel with such esteemed panelists. Some are old friends. So I want to break that question. It's got two parts. I'm going to break the first part, what the considerations are, into two categories. So one, I think, is what are the competition concerns that are arising in these markets? And two, why is Congress so interested? I mean, there are arguably lots of markets where there are competition concerns, but they haven't generated this kind of interest. And so if you take a look at the research and the reports that have come out studying big tech, and I've lost count of how many there are now, but there is, there's the congressional report, majority staff report, there is the UK report, there's an EU report, there's an Australia report, there's a report by the Stigler Center. And what's really interesting about all of these is I think there is actually at some fundamental level a broad area agreement that digital marketplaces tend to be markets with big network effects, which means the more people use them, the more valuable they are, that tend to lead to winner take all scenarios. So eventually over time, one company tends to dominate. And that leads to, I think, two policy implications. One is that there's a lot of incentive for companies in that type of marketplace to engage in anti-competitive activity. And two, because your competition is likely to be not within the market, like car companies compete, but for the market, the way in which Facebook replaced MySpace, that you get these periods of intense competition followed by a winner, and you need to protect those periods of intense competition, because that's where a lot of the innovation and consumer benefit. So yeah, I think that seems to be the concern across generally underlying the enforcers across the world. So, but why is Congress so interested? And I think the issue there is slightly different. And the reason why Congress is interested, it's not just the antitrust concerns. I mean, I'm an antitrust geek, so yeah, that would be enough for me. But these happen to be companies that interface with more people's lives than most companies, right? I mean, particularly after the pandemic, everybody has relied on Amazon, or almost everybody, right? Facebook is an integral part of people's social lives, the way they communicate with schools, Google. And so when things go wrong, everybody is aware of it, right? And so people are worried about content moderation. Are the platforms discriminating based on ideology? But so this is coming up, say, in all sorts of laws. People are worried about the way in which these platforms collect and use our data. I think all of us have sort of the creepy story of, I went to a bar like 2 years apart, and Google Maps was like, the last time you were here was 2 years ago, right? Like, these are all important issues. They're not necessarily competition issues, but I think they are why people are concerned about these marketplaces. So I'm gonna disagree with the premise of the last part of your question just a little bit. I think it's hard to know what's really driving whether there is there's a difference. There's clearly bipartisan interest. And there's some who want to sort of tell this very simple story that the Democrats are worried because they just don't like big companies, and Republicans are just mad at Google and Facebook because they're big and they seem to discriminate against them, or they think they do, their ideology. Okay, so the reason why I don't think that's a good story is, one, you can't say that about ranking member Ken Buck of the antitrust subcommittee. And clearly very concerned about the competition issues. The second thing is you got people like Jim Jordan who are very angry at the platforms, who really oppose these types of bills. And the third thing I think is interesting is on the Senate side, the people who started as only focused on tech, Blackburn, Candor, have started to show a more general interest in monopoly power in the economy, whether it be ag or PBMs. So I'm going to leave it there and not having answered your last question, but probably having talked a little too much.
Oh, well, no, that was great. Thank you so much, Michael. Andrea, you come at this from a different set of experiences. What are your thoughts on what's motivating Congress and Michael just challenged my premise that maybe Democrats and Republicans differ on this. What are your thoughts? You're muted.
I'm muted, of course.
Here you go.
Thank you for including me and glad to be here. I think it's a great question. And I think if we could answer the motivation, we probably have 435 different answers as to what it is that, I guess 535 different answers as to why Congress is interested here. When I think about this from my perspective as somebody right now in private practice, I think that there is some unanimity between Republicans and Democrats, my impression from afar, around the fact that if you control the pipes that people rely on day in and day out, you get to control the messaging. And that has different consequences depending on your position. So I think there may be some people who think that that is suppressing the freedom of ideas. I think there's other people who think that's actually suppressing physical innovation, that if you have one company that is controlling the way that these products that we all ingest all day, every day, if you have one company that's controlling it, you're going to be limiting innovation. That's going to lead to, I think everybody would agree, whether you're a Republican or a Democrat, loss of innovation is a bad thing. But I think the real motivation, it's antitrust in general, and this question in particular, there's just a strange confluence around Republicans and Democrats, sort of the populist right and the very progressive left, that believe if you have one entity that controls too much, then that creates too many negative outcomes. So I think if you looked at any individual congressperson or senator, you'd have many different ideas. They'd come out with many different responses. But I think at bottom, that's what it comes down to, is there's a general discomfort. And frankly, I think this has been true throughout our country's history, with having too much power in the hands of too few people. Now, I'll be clear, I disagree personally with many of the solutions that some people are posing here, but your question is more about what is it that's motivating these folks? And I think that that's what it comes down to.
All right, well, thank you. And Scott, I'm going to forewarn you, I'm going to ask you in a little bit about some of the thoughts that people have about when these companies control markets. I'd just like your thoughts on where that is. But I'm also going to ask you to think in terms of a gentleman who was a professor down the river, or down the road anyway, of where you got your PhD. Pablo Spiller down at Berkeley pointed out to us about 30 years ago that governments tend to jump in and regulate, as Michael was telling us, when a lot of people are affected, when there are very few companies to have to deal with, and the third part was that, they can't get out. They've got sunk costs. That was one of Pablo's areas of research. So I wanted you to reflect on that a little bit, then we'll get to it. But let me get back to the issue of Congress's concerns, because when Congress is expressing concerns, or anyone is, that implies that they have in mind some effects that their legislation might have, and what the appropriate roles then are for, in this case, antitrust legislation. So Maureen, let me start with you. What kind of are the appropriate goals for antitrust? And then Nancy, I'll come to you after Maureen has had a chance.
Well, Mark, for the past 40 or more years, it's been considered that the appropriate goals of antitrust are consumer welfare. Does this impact consumers, who are the, kind of paying the final price on things through, purchases or their choices in the marketplace? So that has been the lens through which antitrust has been viewed, particularly including careful economic analysis. A lot of behaviors that had previously seen as suspect, when viewed through the consumer welfare and the economic lens, over time were understood to actually sharpen competition. So we've seen, different changes, different treatment there. We've seen a movement towards understanding the benefits of efficiencies of scale, of scope, having concerns on competitive effects, typically at higher concentration levels, not really low concentration levels, like has previously, antitrust what was concerned about. very much moving towards the rule of reason, saying what is the impact on consumers of this behavior, moving away from structural presumptions or per se rules. So that antitrust has, its goals are consumer welfare, its tools are economics. The lens that it looks through, the process is this weighing, because it may hurt a competitor, but overall benefit consumers. So those, I think, at least in the courts, have been widely accepted as the appropriate goals of antitrust. I think that that is now being questioned, certainly by some on the left and some on the right. Though I believe on the right, it tends to be a much smaller group of entities that they're questioning this about, the platform companies. And so what we're seeing, I think, is this concern or this idea that we, just for at least for those companies, we need some kind of new set of rules. And the proposals that are being considered seem to be much more focused on competitors, not on consumers, on having competitors have access to these platforms, on having competitors not be disadvantaged in some way by the behavior of these platforms. We talk, Andrea very appropriately mentioned innovation. Michael mentioned, competition and, preserving competition. Some of these proposals, I think, have this presumption that a large company is not going to be innovative, that a large company or a large tech platform is not going to be innovative, and that what we need to do is put limitations on their ability to move into other markets and to create new competition in some of those markets. So hence, limitations on their ability to expand, or their ability to buy up smaller players in adjacent markets and develop new products or improve their products. So I think a lot of these proposals have, fundamentally a rather different aim than what antitrust law has been widely, though I wouldn't say universally, accepted as its appropriate goal, really, since the early 1980s.
All right. Well, thank you. The consumer welfare, the economy is about consumers, has played a very big role, a dominant role in antitrust in the U.S. Not always quite so much in Europe, as I think is often pointed out, because there are situations where a company has been kept down in Europe just so it kind of stays like everybody else and doesn't stand out, but actually hold back innovation in some sense. So, Nancy, what are your thoughts? You come at it from an economic perspective, a lot of years in these types of analyses. What do you think is the right role for antitrust? You're muted.
Thanks. So certainly there's a lot of ground where Maureen and I would agree, but I think it's really important not to read something too narrow into this. So what's the goal of antitrust? I would say competition. First, second, third, competition, preserving competition, promoting competition. The consumer welfare standard as a buzzword or a phrase was meant to distinguish between thinking about economy-wide effects of conduct. Let's take mergers, for example. Are we going to include the profitability of the merged firms in our analysis as a benefit of the merger? Or are we going to restrict it to trading partners, who are often, if the companies are sellers of products or services, going to be downstream consumers or customers? I don't think it was ever meant to be a literal interpretation of end use final consumer price effects. Although I think that there are some people who are condemning antitrust because they think that's what it means, and others who are trying to preserve that kind of narrowness. And I think that's a mistake. It isn't consistent with the way we've enforced the antitrust laws. It's not consistent with case law. I prefer something more like trading partner welfare. And why do I prefer that? Well, because I think the antitrust laws protect competition upstream as well as downstream. I don't think that we've ever insisted that we trace the effect, say, of a merger, if it's an intermediate good merger, all the way through the layers of a supply chain to figure out what the pass-through rates are and how that affects final customers. It would be a huge, huge task to do that. It would complicate the analysis. It would make the court's jobs much more difficult. We don't ask it. Courts basically are happy to look at kind of next player in the chain, again, either up or down. And so I think it's really important not to narrow what we do. I think it's also important to recognize we don't just look at price. That might be the thing we look at most in mergers because that's the most immediate impact. That might be the focus of competition in a lot of markets. But if quality is an important element of competition, or if innovation is an important element of competition, we should and can look at that. I think that the important thing to recognize as we think about moving, as Maureen said, toward a more rule of reason, effects-based analysis, more nuanced analysis, is that that's a tool of enforcement. That's not a goal. And I frankly think that maybe we've gone too far in that respect. I think the more we ask for something that might be an academic's dream, right? The kind of thing I might ask my dissertation students to write their, 200-page economics dissertation that they take 7 years to work on, or 6 years to work on. That might be wonderful to be able to do this complete nuanced analysis. But I think if we're, again, to come back to say mergers, we've got a very limited amount of time to consider what the implication of a merger will be, both for the companies who want to get this deal done if it's not anti-competitive, and for the government enforcers who have to decide, is it anti-competitive? And then for the courts. And I think perhaps greater reliance on some simpler structural presumptions, some clearer kind of bright line rules could be helpful for everybody. It could make it more clear to the companies what enforcement environment they're likely to face. And it could make it simpler for the judges to decide these cases, and it could make it simpler for the parties. I frankly think that one of the greatest mistakes of the last, several decades in antitrust enforcement has been this thought that we are at much more danger of cost from blocking mergers that are otherwise fine, or blocking conduct that is either competitively beneficial or neutral. I think we've overstated those costs tremendously. I don't think there's a lot of, in fact, empirical economic evidence that most mergers create efficiencies. I think quite the contrary. That's a project I'm working on this year, but as I read the literature, that's just not supported. And so I think we've got this imbalance now, and it's time to sort of push us back, both in terms of the way we're enforcing the laws, but also in terms of the way courts are thinking about these actions.
All right, so one follow-up question. So you were talking about maybe it'd be nice to have some structural kind of bright line rules. Economics went through a lot of debate, your colleagues, my colleagues, over a long period of time, over whether structure drives performance, or maybe the company does really cool and people just join and buy there and they get big. So how do you talk with without going into too much jargon, how do you talk with your economics brethren about how those bright line rules might be helpful?
So the first thing to say is, I think that debate is much more applicable to thinking about conduct than it is to thinking about mergers. Mm-hmm. Because with mergers, we know why the companies are going to get bigger. They're going to get bigger because they're buying one another. They're merging with one another, right? And so we don't have to have this debate of, is structure driving performance or is performance driving structure? What's driving the structure in that case is two companies deciding that instead of being independent competitors, they're going to merge and stop the competition between them, and act as one in the market. And so I actually find that debate mystifying in the context of merger policy. Okay. And in fact, as I look back at some of which I've been doing more recently, look back at some of the literature, the work that Harold Demsetz, for example, did, or I've gone back and reread Bork, which I read in graduate school in the early 1980s. there's a whole set of assumptions that are built into there that kind of elide this issue where, Harold Dempsett says, look, companies might get big because they're more efficient. So they take more, they grow, they take more market share, that increases concentration. That's good, all fine. And then he slips in there, therefore, a program of deconcentration is bad. Well, maybe. And then he goes a further step, which I think is getting way, way out on a very thin limb, and says, therefore, we shouldn't be aggressively enforcing against mergers. And I just think, there's no consistent logic to those, getting that far beyond it. Companies always have organic growth available to them. I think you need a pretty compelling argument from the companies as to why they couldn't grow organically to achieve, if it's, say, an economy of scale.
Okay. All right. Thank you very much on that. So we've been kind of laying a foundation for being able to talk about what kind of good legislation there might be. One more piece of that was, so we've talked about what's Congress worried about, perhaps, to the best of our knowledge anyway. What might people actually be trying to accomplish, at least, again, to the best of our knowledge. But there's, as we've talked about, there's a lot of people that talk about, well, there's all these studies that say that competition is on the decline and it's just a lack of good antitrust enforcement. Scott, let me turn to you. What are your thoughts on this kind of intellectual foundation that's laid in such studies? If you want to talk about kind of the opportunism issue, that's fine, but maybe that gets a little too esoteric. So what are your thoughts?
Yeah, I mean, the opportunism question, it's very interesting. I mean, it's really about, it's the question of, why now? Why is all of this happening now? And it's sort of the intersection of the motivation to do something and the ability to do something. And of course, the time meets all the criteria that you or Pablo Spiller mentioned, and it's also politically popular. I think there's an element of governments wanting to make sure that they don't lose too much control. I mean, we see similar. I hate to compare anything that happens here to something that happens in China because they're so different, but we do see similar antagonism towards big tech in China too, maybe for different reasons. But there's some similarities going on there. But that's let's go back to antitrust. And I think Nancy's distinction on the structure, conduct, performance paradigm and when that's useful and when it's not is a really good one. So there are two parts. One is when you're looking at a merger, a specific merger where it's not so relevant because, as Nancy said, why the company's getting bigger. It's because they're buying another one. And when you're trying to think about what competition or how competitive the overall economy is. And that's where it gets to be much harder to think about. So first of all, it's hard to think about the economy as a whole being more competitive or less. It's so, the economy is so complicated, and that's why I'm not a macroeconomist. I don't want to try to think about the entire economy as it's one thing. And so, industries will become more or less competitive, at different times. Some, of course, are related to others, but you want to look at it by industry sector. It can be by geography. And most of the research that has been done on it does look at concentration. And then sort of implicitly equates concentration with competition. And that's where the problem is in terms of policy. We don't, that's not necessarily, those aren't necessarily the same thing. And Nancy has done the best, the best work on this, and including summarizing all the other work and so on. So, if I say something wrong, she'll know it. But it seems like basically, the work shows more concentration at a national level among the biggest firms, but not so much at more local levels. And we don't see we don't see good evidence that the increased competition has turned into the increased concentration has turned into less competition overall. It's just a really, really hard question to answer.
Okay, thanks. So Nancy, any final words on those? I've already asked you to talk about some of the foundations. Anything else you would add?
Would just say, while I think that Scott's right, that a lot of the sort of media interest, maybe even some of the policy interest and debate has focused on measures of aggregate concentration, and there's also been some aggregate studies of markups and profit rates
Sure.
that sort of links into that. I have to say, as Scott alludes to, I'm skeptical of a lot of that work, and it's not, as we're doing more, as people are doing more and drilling down, it's sort of, even those trends aren't holding up across markets very well. But I would say, I think we have some evidence that we have a competition problem. And I think that just relates back to antitrust enforcement. I think for a variety of reasons, we see under deterrence of anti-competitive behavior, including mergers related to weak antitrust enforcement. And I think a huge part of that currently is being driven by inadequate resources for the enforcement agencies. And another big chunk of that relates to the difficulty of successfully litigating certain theories of harm or certain types of cases. So I would say, if we've got a competition problem, and I think we do, certainly have a competition problem in certain sectors, and I think we have a broad economy-wide problem we should be addressing. I think the latter I draw from my experience in antitrust and what I see in the data on antitrust enforcement.
Okay, well, thank you. And for the audience, if you've not been up to your armpits in antitrust work, what Scott and Nancy in part are alluding to is that in antitrust, we look at market power, which means we have to define market, then we have to define power. And we do that by looking at, where do customers choose? Customers in, where I live, Ocala, Florida, don't drive to Atlanta, Georgia to buy a new car, then that's not part of the market, for cars in Ocala. So the economy-wide studies don't really address the market power issue directly. They might give us some good information on other issues, but it's a little hard to sink our teeth into them when it comes to antitrust work. They're good broad indicators, but we just can't draw strong conclusions from them. Those were good points. So now so we've laid our foundation.
Actually, could I interrupt for a second?
Yes, Scott, go ahead.
If I could play moderator for a second, I just wanted to follow up on something Nancy said, that it's a function of what you believe weak antitrust enforcement because of financial constraints among the enforcers and difficulties proving certain theories of harm. Does that mean that you believe there's essentially not a problem with the antitrust tools and approaches, and that there just hasn't been enough? They haven't been. The agencies haven't had the resources to use those tools fully, or is it something deeper that some people believe?
So I think when I alluded to the difficulty of successfully litigating certain theories of harm, I don't know if you want to call that tools, but let me give you a few examples that might help clarify what I mean by that and how that's distinct from just a resource limitation. So if we think about, again, I'll go back to mergers because there are a lot of them. They've been increasing over time. Bill Baer described the merger tsunami, which I think, in 2015 is still going on. Potential competition or nascent competition mergers, are extremely difficult, I think, to litigate. Mergers where the primary harm is to innovation, I think, is difficult to successfully litigate. On the conduct side, things like predatory behavior, exclusive dealing. So I don't know if it's that we don't have the tools. It maybe is courts are expecting, my colleague at DOJ, Dave Gelfand, called it the CSI effect, that when DNA evidence became ubiquitous, then juries thought, well, if you can't link the alleged perpetrator with DNA evidence to this crime, we can't convict him. And in antitrust analysis, it's like, if we can't quantify an effect with an econometric model to the fourth decimal place, it must not be a real harm. I think some of that is going on, and I think that's less about tools and more about, we somehow have this misguided view that using economics, which I think is important in antitrust enforcement, means econometric evidence. And sometimes it should just mean documents and witnesses that say, no, these two companies are potential competitors, and the one buying up the other is going to reduce competition in the future. So that's, is it tools? Is it expectations? Is it courts? What is it? That's kind of what I mean by that, Scott.
Okay. So let me pull our attorneys back into this. The three economists have had a lot of fun. So let me get back to it. So Maureen, I'm going to ask this question of you. There are a lot of bills in the Senate and in the House. I've written about a large number of them, and there are some I haven't even touched. Some of them are pretty aggressive. They might force companies to shut down entire lines of business or spin them off. Others have little controversy, like Scott was just alluding to, giving the regulator some additional funding. What do you believe are the productive things that Congress could really do in the antitrust area?
Well, I think one of the best things Congress could do, and Michael mentioned this at the beginning, is not an antitrust fix. It's actually passing a federal privacy law. Because a lot of the concerns that we hear, involving, tech platforms and those kinds of issues actually, I think are growing out of concerns about, collection, use, and sharing of data. So I think antitrust is not the right tool to address those, but people are trying to use antitrust in some ways because of, I think, of a frustration that Congress hasn't yet passed one, and we're long past due when Congress should pass a federal privacy law. So I would put that on the list. Certainly more funding for the agencies. I completely agree with Nancy about that. But one of the things I think the agencies could use that funding for is to look at studies and do additional studies that show where anti-competitive things that maybe our tools currently aren't detecting correctly, or better ways to forecast what's going to happen in a market. For example, when Tim Muris became chairman of the FTC and DOJ had lost a string of hospital merger challenges. The courts just weren't accepting the agency's predictions. So he invested in doing a retrospective of them and producing reliable evidence, and he really turned around the whole hospital merger program. And I think that's paid enormous benefits since. And so if there are behaviors that are happening, whether they're mergers or whether they're conduct, that the agencies are just faltering on being able to prove in court, it would be great to invest in those kinds of foundational kinds of proof. One of the other things, so a slightly heretical view of mine, at least at times on the Republican side, is I think, in mergers, the agencies enjoy a presumption under the Philadelphia National Bank test, right? So I always thought that was a good idea, and I wouldn't want to see that overturned. Now, it is a rebuttable presumption. It's not, I wouldn't call it a structural kind of thing where you say, we know for sure market power over 30%, or a market position over 30% is per se bad. So I think either through putting that into a statute or just making sure that is not undone, I think that would be really a key thing. One other thing I want to mention that Nancy discussed, like I completely agree that we shouldn't just be looking at price, and I think that's a bit of a red herring that's been thrown into the debate, particularly because then it said, well, if the ultimate consumer is not paying a price, therefore antitrust can't do anything. I think it way misses the mark, particularly in two-sided markets. Somebody's always paying a price somewhere, right? So I think more sophistication around that would be helpful. Now, some of the things that I am concerned about, right, is, for example, if we are, Nancy talked about the merger tsunami. My experience has been that mergers are driven much more by underlying fundamental issues, markets, with capital markets, things like that, than they are in whatever the antitrust environment is. And so we see it kind of flow through different industries as they're seeing different changes. So the idea that most mergers are not even necessarily mergers of competitors. And, so this idea of whether there are efficiencies or not, that really only comes into play, I think, when the question is, well, are they competing now, and will that competition, be removed from the market in a way that hurts consumers? So I would be concerned about doing something through legislation that just basically puts a bar on mergers by certain companies. And that's one of the things that we're seeing. And then one other thing is, the agencies can, I think, if the documents, the economics, and the customer evidence line up, successfully challenge acquisitions of nascent competitors. I brought a case when I was the acting chair in CDK Automate, and was focused on quality. It was focused on innovation. We didn't have to litigate it ultimately because the parties abandoned it. But I think that is certainly an example of the ability to do that. So just to kind of say, I think some low-level rebuttable presumption and more resources and a federal privacy law, I think, would go a long way towards addressing some of these concerns.
Okay, thank you for that. So Michael, she cited you as a source. What are your thoughts on what is it that Congress could do that'd be really productive here? You're muted.
I feel like we should have a game, and who's ever the last to forget to unmute wins. So let me start, and joining the kumbaya moment of the agencies need more resources. And let me put that into perspective. That essentially agency funding from 2010 to 2018 was flat. The last 2 years, there's been a small increase. Okay. The number of mergers over that time has more than doubled now. The economy by 2018 had grown 80%. So, I remember when I was at the agency and we were not getting more money, there was always this sort of tough guy attitude. We can just do more with less. But there comes a point where you can't do more with less. You just do less with less. And so we have I think, a massive increase. And if the Build Back Better program bill is passed, that actually has $500 million for each agency, plus some more for FTC and privacy. I think that's important and necessary, but I think there's a lot more going on in the courts. In what I like to say is, over the last 40 years, what I think, with some exceptions, antitrust law has developed in the courts a view that you have to prove water makes things wet. And so the agencies are stuck litigating basic issues, having to convince judges that, I watched an economist, try to explain to a judge that if you have market power and if excluding competitors is profitable, you will do that, even though they say they won't in testimony. That shouldn't be what our antitrust case law is about. If we look at AT&T, right, this most successful breakup in antitrust history, I think there is a good argument that there are courts out there that would reject would say that the fundamental theory of the government's case is not an antitrust violation. That's a huge swing. Okay, and if we expect the antitrust laws to deal with dominant firms today, we need antitrust laws that will focus on the problems. And so I think if Congress wants antitrust to be, if it wants antitrust to play a role in society, they need to tell the courts how they want the antitrust laws interpreted. for, throughout its history, the antitrust laws, we sort of call it sort of quasi common law, meaning we have these broad statutes, the courts interpret them, and the law sort of grows and changes over time. Nothing wrong with that a priori, but the courts have made it clear how they're going to interpret those laws. And if you want a different result, I think Congress needs to step in and say, no, we actually don't want every antitrust case to require proof of first principles. We can create better presumptions for mergers, and we're going to overturn certain court decisions that have led to bad results. And so I think as a general matter, those are the sort of reforms that are needed.
I add sort of what you've just heard from Mike and Maureen are sort of at the policy level. As someone who does this day in, day out in the weeds, I actually think there are changes that the agency should be thinking about itself now, and that Congress should be considering in some of its statutory reforms that are very unlikely to have any kind of pushback. So you think about, what do they do when they get an HSR filing? Well, they actually have to look at an HSR form. The form is really unhelpful in providing the antitrust attorneys at the DOJ and the FTC with real-time insights into the market dynamics. I think if you look at what our friends in Europe and in other jurisdictions require of their merging parties, it's actually a document that's much more meaningful and much more impactful, and actually gets people into the merits of what it is we're trying to do here. The only thing that I've ever seen attorneys, when I was at either agency or in private practice, use from the HSR form are the 4C documents, which should continue to go in. But there's really more that can be done in terms of how you prepare to explain your transaction to the agency, if we had any flexibility to do that. When I was at the FTC, we talked about, should we revise the HSR form, and it didn't really go anywhere. I wish it had, because I think that that's a change that the FTC could go through. I think it has to do with rulemaking. It's got to go through some APA processes, but I think that that's something that could be helpful. I do wonder about the 30-day waiting period. That's, of course, in the statute. I think there are some deals where 1 day is too long for the waiting period, and there are some deals that should just go through right away. And then I think that there are probably a good tranche of deals that might benefit from something that's a little bit longer than 30 days, not materially longer, maybe 45, maybe 40, maybe 35. But I think as you think about the work that the FTC and DOJ staff attorneys try and do, is it really fair that there's only 30 days? I don't know. The clearance process, something that Congress ended up weighing in on, and not allowing a very clear delineation between the FTC and DOJ, eats into that 30-day waiting period. Maybe that's something that if Congress could really get its arms around, so you would know on day one, your audience is the FTC, and you would know exactly whom to call, exactly what to provide them, you could make that 30 days more productive. So I think there are a host of not just policy ideas that Congress should be thinking about, but again, as someone who lives in the weeds, there's procedural things that are too easily overlooked and that could end up working to benefit both sides. We are not, my clients aren't out to do anti-competitive deals. As Maureen was explaining, they're out to do deals that actually have good pro-competitive rationales. We want time to make our case. We want to have the ability to make it in the most compelling way. And sometimes the processes don't allow for that.
All right. Well, thank you for explaining that. I only worked for one corporation in my life, that was Sprint. And this is way back in the old days. So it was a long distance company, which we don't have any of those anymore. But at one time that was a market. And it had grown, sort of grown, through mergers. And one of the lessons the company learned is that when you buy a company of people who chose to not be Sprint customers, they would again choose to not be Sprint customers. It was really hard to grow that way. But I also learned that the filing requirements and dealing with the regulatory agencies, and whether it be FTC, DOJ, or the Federal Communications Commission, or any of the states, that was a lot of work. And clarity matters a great deal. So I appreciate that. What I've heard you conclude is that primarily things that Congress could do would be, yes, the additional resources, make sure we separate out issues like privacy that aren't really competition issues, that we try to get some clarity on what might be a rebuttable presumption, where we might have some bright lines of some sort, and then just clean up the processes so that companies can actually make some decent business decisions where now they struggle to know. That's really helpful. So we're not talking, none of you are suggesting some of the things that we see today, like it's illegal if you're a platform to actually sell anything on your own platform. Or if you're such and such a size, you just can't ever acquire new talent or new patents or whatever through an acquisition of some sort. That maybe we can evolve and learn how to do that well, better than we perhaps have done in the past. So let me ask a different question then. And Nancy, I'm going to go back to you for this one. Let's assume that Congress's concerns that we started out with are indeed valid, and there's really perhaps some concerns about how these companies do or don't compete and where these markets perhaps go. There is debate over whether the remedies what the remedies are that should come through antitrust, which typically responds to bad things companies do rather than have regulation instead. In the current environment, what do you think is the right approach for the problems people believe that are there, whether we agree or disagree? Is using antitrust the right approach, or like the Federal Trade Commission is wanting to do, and that is get into some what we call ex-ante regulation, to set rules. Company, you will behave this way. Well, what are your thoughts?
Well, I think it's probably a combination. To go back to something that Michael said, one of the things that's important to recognize about these platform companies is that many of them are operating in a kind of winner-take-all environment where, maybe once every generation, whatever generation is, I'm not people lifetimes, but company lifetimes, the market's really contestable. You might have some new technology that comes in or some new way to attract customers. And it's important that we have a competitive landscape that facilitates that and, for example, prevents a dominant company from a dominant platform from buying a firm that could evolve into being a competitor for it and perhaps take its market away. So I think that that just comes back to, do we have an effective antitrust regime where we can relatively quickly and credibly bring those cases? Because if we can't, then because antitrust is fundamentally a deterrence-based system, if companies think, well, if I exclude my rivals, if I take a hypothetical, if I'm Google and I pay Apple $1 billion a year to make me the default search engine as a way of, maybe it's to keep Apple from having an interest in developing a competing search platform with me. Even if somebody gets wind of that, it's going to take them several years to investigate. If they file a complaint, it'll take several years to litigate. I'll get to appeal, 10 years down the road, who even knows what this is going to look like? And so why not go ahead and gamble? So I think having some credible enforcement, clear ability of antitrust enforcement to act on any competitive conduct, or the same with mergers, is important. That said, some of the concerns in the tech space, as it's been alluded to, are really not antitrust concerns at all. Maureen mentioned privacy. We had an earlier discussion about speech issues, the kind of political power of mega companies. That's not exclusive to tech, but they are definitely mega, maybe ultra mega. Income distribution has been mentioned, labor share, wages, and so forth. In fact, some of those might even conflict, like privacy and antitrust might be at odds, because protecting consumers' privacy might restrict who gets their data, and that data might be important for a potential competitor to be viable. So I think, to the extent that those concerns are outside antitrust, we definitely do not want to be broadening the antitrust laws to pull them in, as has been suggested by some people. To the extent that we can address some of those concerns through traditional antitrust and increased enforcement, maybe with some of the legislation that Michael alluded to, that creates stronger presumptions or shifts burdens or overturns some of these bad case law precedents. Let's leave that to antitrust. But I think as we look at the tech space, we're likely to see problems that are going to need some type of ex ante maybe call it light touch regulation. So not the conventional, telecom regulation that you were familiar with and we spoke of, going back to the AT&T case. But something that's more light touch and maybe even tailored to specific, I don't think you can say tech or platforms, maybe tailored more to those. And I think what the CMA is doing in the UK is quite interesting because they've got a combined authority with antitrust and this kind of regulation and have been instructed to think about tailoring regulations, investigating and then tailoring regulation to specific problems of specific platforms or companies or types of business models. I think that's got some promise. That said, as anyone who's worked in the telecom space knows, but not just in telecoms, it's easy to say, oh, let's regulate and solve a problem. And it's really hard to get that regulation right, especially in innovative sectors. And so I am worried if we're going down a regulatory path that we try to keep that, as far from conventional utility regulation as we possibly can, because I think, that's historically has been an innovation killer in sector after sector after sector. And it would be terrible to lose all the benefits that we have from the tech space by clumsy regulation.
All right, thank you, Nancy. Scott, you've had experience with the regulatory agency. What are your thoughts on should ex-ante type regulation say, here are the rules, you will do this, this, and this, or the policies like antitrust that says, here's the boundaries of bad behavior, and don't cross those lines. What are your thoughts?
Yeah, that's a good question, and I'm going to answer a different one. But people on the panel have offered some, very thoughtful ways that Congress could intervene and legislate. But we don't see that kind of thoughtfulness in the actual proposed legislation that exists. I think it takes two tacts. One is that if anything could ever lead to a bad outcome, then it should never be allowed. So it becomes almost impossible to make any acquisitions. And like I believe you said, Mark, it's almost impossible to offer your own products and services because you can't improve them. And those are based on the real concerns that you might favor your own product anti-competitively or buy companies to prevent them from being competitors. And those are certainly bad outcomes that are possible. But we know that good outcomes from these things are also possible. Stores offer their own products all the time. Being acquired is an important reason for anybody to build a company in the first place. If it's impossible to be acquired, we are likely to see less innovation on that side. And so, Nancy talked about bright lines, but that strikes me as way too bright a line, or at least too far. It goes too far. It just decides if anything can ever have a bad outcome, we won't allow it. And that's just not very thoughtful legislation. And the other part of that then does actually go to your question. Some of it is billed as antitrust legislation, but it seems to turn the FTC into more of a regulatory agency. So I forget the names of which bill is which, but they require the FTC to create these technical committees that would have to approve changes to interfaces and how companies that need access to a platform can any changes to that interface that other companies need access to, and that's very definitely a regulatory action, not an antitrust action, and probably going down the wrong road of regulation. But then it's an example of they're trying to bring in regulation under the guise of antitrust when it isn't, even without having any of this kind of important conversation about if you do want regulation, what is it you want to correct for, and then what's the best way to do it? Because we mentioned, as we've said several times, there are lots of different issues that people are concerned about, and if people believe that those are things that need to be regulated, it needs a much more thoughtful conversation on how to do regulation, what we've learned from the past, and so on. You can't just put it into 3 lines of a bill and turn the FTC into a regulatory agency.
Let me ask the question. I don't have. Go ahead, Michael. Yes, go ahead.
Yeah. No, thank you. So just a couple thoughts in response. I think one, I don't think the Access Act, which requires interoperability, or any of these bills are that apply to the tech platforms and necessarily they're called the sponsors are calling them antitrust bills. In fact, in some sense they're not, except maybe the merger bill. The second thing, I think it's worth thinking about the legislative process a little bit here. Part of the reason, sometimes you introduce a bill and it's kind of baked. That's really hard to do. And you can end up never introducing. Sometimes you introduce a bill that you have no interest in getting passed. It's called a messaging bill. And sometimes, most of the time you introduce a bill to get ideas out there, and then ideally the legislative process is supposed to work. And over time, there's lots of thought, and the result is probably nobody's happy, but we're a democracy. We muddle through, we don't want perfection at some level, because that usually comes from far less democratic institutions. And so one issue is the bills, particularly the tech bills, have been out there, and the industry is not interested in negotiating on those. And I'm not saying that they're wrong or that they should, but to the degree those bills need to be tailored, you really need an engagement process. Otherwise, the sponsors are kind of just negotiating against themselves. And the final thing I would say is, and I think this is really important, goes something back to Nancy. I'm going to take her antitrust point and make it more broadly, right? I think a lot of economists, lawyers, we tend to be risk averse, so we worry about the downside risk. But we were told that, but I think you also, from the legislative process, we have to be worried about the danger of inaction and the harm that it can cause. And I think there's very serious issues being raised that dominant platforms can have a tremendous harm on innovation and on also competition. And, one of the things Senator Klobuchar told me is oftentimes you're picking between two things. And you got to figure out hopefully which one's better, and sometimes which one's less worse, but non-action is as much of a decision as action. So just wanted to sort of respond just a little bit. So thank you for that opportunity.
I'd like to respond a little bit to that, actually, if possible. So these are very clearly targeted at competition. In fact, the Access Act starts off by saying to promote competition, lower entry barriers, and reduce switching costs for consumers and businesses online. Maybe maybe you want to separate competition versus antitrust, but I think it's not quite right to say that it's focused on a different area. I also, I'm not sure if the negotiation point is if you're saying that it's okay to introduce terrible bills because you're expecting to change. This is, I'm commenting on the text of the bill itself. If you think that if you have an idea of where you think it should end up, I'd certainly I'd like to hear it. But it is based, I think, on a premise that you're saying, which is that you think these platforms harm innovation. And there is the legislation, and none of the sponsors have offered any evidence to that, any evidence at all, or even any recognition that there's a balance, that the things that they're saying can have costs and they can also have benefits. They act as if there's only a cost to the things that they want to ban. And I don't know anything about legislative negotiating, but to me, that's just a very disingenuous approach. And I would prefer something that's just more thoughtful. And ideas that Michael, you articulated yourself at the beginning, very, thoughtful approaches to what legislation would look like.
Maureen, could I pull you in a little bit on this type of a question? Because I'm on a lot of panels, have lots of discussions with people, and we all struggle with how can we be effective here in trying to bring good substantive arguments to a process that does involve a lot of signaling. And Michael didn't talk about this, and maybe it was never in any of his experience. I had a friend in Congress. I asked him about some bills that were in the works, and So what are the prospects? I said, oh, those will never get passed because they're just there so that people, make political contributions, so that they know we're paying attention. This is a pretty messy process. What can we do that's actually effective and help move things towards a productive solution? We talked about some things that we have a fairly reasonable agreement within the panel. These things would be productive. How can we be helpful?
Well, one process for passing, substantive legislation, I think should be hearings on the bills, right? I don't think we've had those. So for engagement, I think you might want to have hearings on the particular proposals, and that has not occurred. I think, certainly anyone can reach out to members of Congress, members of the committees and their staffs on these issues. And look, I also, they're often, in my experience, thoughtful staffers are open to, hearing about things. They don't necessarily, have themselves deep experience in these. I mean, some staff do, but not always. So I think the education function that either, that hearing should play, and that outreach can have, and also these kinds of events and papers and things like that people who want to be thoughtful about these things can draw upon, I think is a useful channel.
All right.
Can
Andrea,
I jump in here?
what are your thoughts on that?
Go ahead, Nancy. Go ahead. You got your hand up.
Okay, go ahead, Nancy. I'm sorry.
That's okay. I just wanted to respond a bit to something that Scott said, which is, I think it's a mischaracterization to say, there's a lot of legislation that's been proposed in Congress over the last couple of years. It's a mischaracterization to say that it's all, extreme. I take something like the Competition and Antitrust Enforcement Act that Amy Klobuchar introduced in March of this year, which I think was it's not that every clause in the proposed bill would be something that I jump up and down in excitement about, but most of it is really sensible, I think, antitrust reform that is very consistent with the kinds of discussions that we've been having here. So it's not, broadly speaking, it's thinking about what's gone wrong in terms of operating an effective deterrent system in antitrust and being able to get cases successfully through the court system, and what do we need to do to change that. And so I think it's unfair to say everything that's currently in Congress is, either not really about antitrust, or it's, attacking a single company, or it's preventing companies from, just bright line rules preventing companies from doing anything. So I think there's some good ideas that are worth considering and pursuing.
Yeah, that's fair. I was talking mostly about the House bills. I think you're right. No, that's a fair point.
All right. Well, thank you all. So I still have questions left, but I'm out of time. So I need to now turn to our audience. We've got a couple of questions from the audience, and I'll read them off. Maureen, the first one is targeted to you, but if anyone else wants to jump in, please feel free. It says, Maureen, earlier you argued that passing a federal privacy law would alleviate most of the concerns put forward in some of the antitrust proposals. To me, the questioner, this seems true for the concerns coming from the left, but the energy behind these bills on the right seems to be more driven by spite and anger about speech-related issues. In that sense, antitrust is being used as punishment for something pretty unrelated to antitrust and consumer protection. Is a privacy law the best way to deal with these concerns, or would it be something more like amending Section 230?
Well, look, a privacy law is going to focus on the collection, use, and sharing, and access and correction, all those things of consumers' personally identifiable information. Let's hope it might also have a data security element to it as well. And, to prevent against, bad actors getting access to that data. But it does seem that for some, particularly on the right, who are supporting these bills, what their issue is that they don't like how these platforms have treated certain types of speech, right? It's not a privacy issue. It is, a content issue. Section 230 was created to essentially allow platforms, right, where others can post content. And we in the US, fortunately, which Europe doesn't have, and we see this, globally, we have the First Amendment too, right? And so that should provide, I think, protections to editorial decisions about content. So I'm, Section 230 is sort of outside of my area, and I'm not going to weigh in on it. But I would say that privacy concerns go a long way, but they don't. I agree, they don't control everything. But I also think we shouldn't lose sight of First Amendment protections that everyone in this country should enjoy.
All right.
And that includes, compelled speech, as well as, the ability to say what you think.
Okay, thank you. Anyone else like to chime in on that? All right, so let me go to our second question then. AEI scholars Daniel Lyons and Jim Harper have argued that Congress has been abdicating to lower federal agencies, particularly on tech issues. So rather than just take a responsibility and write legislation, to say, let's, those agencies, they'll deal with all the tough issues. Even if you're a free market conservative who opposes these antitrust bills, isn't it better that Congress does something bipartisan to address popular concerns about tech firms' conduct, rather than shooting down these bills and leaving it to agencies dominated by progressives? Anyone want to address that? It wasn't targeted to any particular person. So what's the value of a bipartisan approach as opposed to leaving things as they are? Michael?
So I think, right, I mean, this is government 101. Congress represents the people. Congress passes laws as long as they're constitutional. They reflect the democratic process. And also, look, we earlier, Maureen, we was talking about what antitrust law can do in terms of protecting competition, and that's the right debate lawyers within the world of antitrust has. Congress is not constrained by that, right? So Congress can decide the rules of the marketplace through its ability to regulate interstate commerce. And I think what the question's getting at, and I think I agree with it, that in some sense, it's better to have this decided Congress, it's better to have Congress decide that. I'm not going to say, and if not Congress, then we don't do anything. I think I'm far too practical. I think, if there's a problem, you find you do what you can to address it. And I would also say, I think and what I really think Congress, if you look at those bills, even the high-tech bills, they're mostly about burden shifting. They're not banning anything, right? And so that is sort of a judgment about risk of over versus under enforcement. And the courts have made one determination. I think it's perfectly fine for Congress to come back and say, we don't like that. We think you've gone too far. So we're going to do this by flipping the burden. But I think that Congress should speak on these issues if it can, and if it's bipartisan, more the better.
Anyone else?
Also, could we also observe, I think there was a barb in that question about, delegating to agencies that are run by progressives as though, well, I won't even say, but let me just remind us all that the agencies can decide to bring or not bring cases, but they don't get to decide what the antitrust outcome is or the policy is. They have to go to court and convince at least one federal judge, if not many, as it's appealed up through the system, that the case that they're bringing falls within the confines of the current understanding of antitrust law or their understanding of antitrust law. And so, that's as I alluded to before, I think that's an enormous constraint on what can be brought. I think personally at this point, too much of a constraint. I think we're missing anti-competitive conduct, but it's not as though if Congress doesn't act, the agencies are going to run wild, at least in terms of outcomes, right? They could bring crazy cases, I guess, if they wanted to, but they're unlikely to prevail.
Let me just add to that. I mean, yeah, Michael's of course right. It's up to Congress to set Congress makes laws, but just to put in a plug for the staff of these agencies that supposedly are just all progressives. I mean, the staff they're really good. These are smart people who know the laws and they know economics and they're dedicated. It's just implicitly bad mouthing the staff of the agency is not a good road.
So I just need to say I was not intending to badmouth.
Oh no,
staff.
I didn't mean you. Not at all. No. I meant the.
but I want to be clear. Right, I was sort of answering this big theoretical question, but regardless of what Congress does, the agencies have a duty and obligation to enforce the law as they best see fit. And I totally agree with Scott that that the staff at both agencies are dedicated to that. And there's a lot that they can do. So I just want to clarify my position.
All right, thanks. So then we have a third question. Andrea, this is for you, although after you answer, anyone else can jump in as well. It says that you mentioned some common sense reforms to antitrust laws that could make existing merger proposals more beneficial for consumers. But these types of proposals don't get people in Congress elected or reelected. Do you have faith that common sense measures can make their way into these bills?
Oh boy, that's a very deep question that I guess goes to the core of my personality. Do I have faith that people can do the right thing? I do. I think that it's unlikely to capture imagination and attention in and of itself, some of these ideas that I put forward. But do I think that there are sensible people on both sides of the aisle that if you had someone from the FTC and the DOJ that went in and talked to their staff and said, here are things that are not political. They are efficiency enhancing for everyone and no one is going to be upset about them. Here is the language, cut and paste, put this in, I will email it to you. Do I think that they could make their way into our legislative process? I do.
Anyone else? Yeah, I think my own experience would be somewhat similar to that. I've been surprised over the years. I've worked in agency staffs. At the times I would get listened to. That was amazing to me because I carried no political clout whatsoever. And I also keep in mind the difference between agencies and elected officials. A good friend of mine used to be the head of the utility regulatory agency and ICT regulatory agency of the Bahamas. His father was a politician in Trinidad and Tobago. And every time my friend Stephen would say, gee, we should do this, Parliament's done something over here, his father would say, well, who elected you? And I thought that was always a good point to keep in mind, that at the end of the day, we all work for the voters. And they will have their say in whatever direction things might go. All right, we have a fourth question. And again, it's not to anyone in particular, so I'll open it to anyone. Says, could one of the panelists who supports these bills, and I'm not sure anybody supports all of them, but some of you have been more positive than others, who supports these bills, highlight what they consider a weakness in them. Likewise, could someone who opposes them identify what they consider the strongest proposal? So I don't know if you want to put yourself on for or against bills, but just in general, what's a weakness in bills that otherwise might seem positive, or what's a strength in what might otherwise might be a questionable proposal?
Well, I guess I was I was probably the most anti these bills, so I'll say something positive. I mean, the agencies need more resources, like we talked about, and that's part of this. I think everybody agrees with that. And the other is, I can't remember actually whether this was part of the bills or just part of the debate. There's discussion about going back and revisiting previous mergers, and in the bill, and the talk is about then trying to undo them. I don't think that's practical, but retrospective studies, of course, are incredibly useful. And so I absolutely agree with I don't think you can do too many of those.
Yeah, that's a good point about the retrospective studies. I was talking with the regulators, Association of Regulators in South Africa a few days ago. And they were struggling with how we're going to deal with all the dynamic changes going on around us globally and within our own country. And it was all about speeding up our review processes. We've done something, within 3 years, we ought to be looking at it and say, what did this really do? Were our assumptions correct? Where did we get things wrong? What did we learn? And that's one of the discussions we had. When you take an action, it's not that you're trying to solve a problem, you're actually just trying to learn something. And so how do you process, how do you make sure that learning occurs, how do you process it, how do you make a new decision with it? Anyone else? What do you see that's, yeah, okay, so that's a really good idea, or no, that's not so much? Strengths or weakness?
Well, one of the things that we haven't talked about is not just what the bills say they want to do, but the kinds of punishments they authorize should a company essentially violate the provisions. And so I think that's another kind of extraordinary thing on some of these bills, the enormous penalties that they would apply that are unrelated, untethered to any type of competitive harm. And also some of the requirements that would take away the CEO's compensation. It doesn't even say compensation from being employed at the platform. They're all the compensation they received in the last year. And I think that should be another important factor in assessing what are these bills really trying to achieve when they put such incredibly draconian obligations on it. And while Michael mentioned that they maybe they have burden shifting, but they also are now kind of flipping the burden for companies to prove that they are not even things that they're permitted to do, that they're not doing them too broadly, or that they don't have more of an impact than what they absolutely need to protect privacy or security or something like that. And if they get it wrong, they are theoretically putting at risk huge amount of money and also their executives. So I think that also needs to go into the understanding of what might the impact of these bills be, which is to sort of make companies be very, very, very fearful of taking what was, previously very common actions by any business in the marketplace.
Okay.
I'll weigh in as someone who's a fan of legislation, but not all of it. I think some of the bills or provisions that disturb me most are ones that are written with for companies in mind and blanket bans. So, something that says if your market cap is over X, so that I've picked X to just capture, 4 or 5 tech companies, you can't buy any company regardless of its size. Strikes me as counterproductive. I think we do have to struggle and figure out how we deal with if you want to call them killer acquisitions or potential competitor acquisitions or whatnot, where the companies are small but could prove a significant threat in the future, we have to be able to enforce against those. But the idea that all talent acquisition, most of which these days, team talent acquisition, most of which these days is done by an acquisition structure, I think largely because of tax reasons for the guys who own it, or the employees, that we would ban all of those strikes me as potentially as overkill and potentially dangerous. So I'm much more in favor of really building up the enforceability of our antitrust laws across the economy. Right now, we're worried about tech, but there are other companies that are problematic and may not be big the way some of the tech platforms are, but we don't want to destroy competition in those spaces either. I'd be much more in favor of legislation like that rather than this, target specific companies and completely ban practices.
Okay, well, thank you. So we're almost out of time. We have 4 minutes left. So I have one more question I'd like for each of you to answer, which means you have about 45 seconds each. What do you think Congress will really do? And if it passes legislation, do you think Biden will sign it? So I'm going to go on my screen, left to right. Michael, you're up first on my screen. What do you think Congress will really do? And do you think the president will sign it if they do something?
So I think there's a good chance that the agencies get a big bump in resources and maybe updating the merger filing fees. I'm going to put an asterisk by what will Congress do, because Congress, it's very hard to pass bills and it can take years. That said, at least from when I was on the Hill, you do have the potential that there are 3 or 4 bills that are going to get voted out of both committees of jurisdiction, which means they can get put into other vehicles that are moving, right? I mean, it's hard to imagine that they're going to spend floor time in the Senate on these, but maybe they would. But these bills have a much better chance of passing than I ever would have thought. And I think, depending on what was passed, I actually think Biden would be very likely to sign the legislation. I think he's made it pretty clear he's concerned about market power in the economy.
Okay, thank you.
In particular.
Andrea?
I don't know. If I knew, I would have much better insights into the future and probably not even be interested in speaking with all of you today because I'd be on a beach somewhere. But I think that I think there's a good chance. I think there is this strange bedfellow coalition that has come together. I think whatever comes out of Congress, I think Biden is likely to sign, because even though he's still shown himself to be practical at heart, even though he's not gotten everything he's wanted along the way since January 20th, he's still signing bills that come to him that have gone through our legislative sausage making process. So I think you will see something that ends up affecting big tech. And I do think Biden will sign it.
Nancy.
And I do think the resources will go through. I think that will go through as well.
All right, very good. Nancy.
Yeah, I think the budget one's too much of an easy, softball. I'd love it if I don't think the craziest bills will go through. So given that, then I would love to see some legislation go through. I wish I shared the optimism, or maybe Andrea's not optimistic, but she feels she's being more realistic and thinking we will get legislation. I agree that if we get something, the odds that the president signs it would be very high, because I can't imagine something coming out that, would be so far outside the scope of what he would be willing. It'd be much more likely be too narrow. But
okay. Well, Andrew, you have great beaches here in Florida. So if I see you at one of them, I'll know that you've now had a new insight. All right, Scott.
Well, it's always a good bet to say that Congress won't do it, whatever it is. But I think your resources. Yeah, I think one of the questions is how the election affects that. And the politicians need these companies. They use micro targeting more than anybody else. I think it may not be a huge amount of money for the companies, but it's really important to all the politicians. I mean, look at their websites. You can find every tracker that exists on all of their websites. And these bills don't get at that directly, but are they, how much are they really going to want to upset the way these things work when it's election time? I don't know.
Okay. Maureen, you have the last word.
Well, I agree that the bill that has the best chance of going through, and I certainly hope it will, is the one that gives the agencies resources. There's wide support for that, and I would certainly expect that the president would sign that. As for the other bills, I mean, I think a lot depends on what they end up looking like when they finally, would actually get voted on. One of my concerns about it, and Nancy, I think, touched on this too, is you have these bills that are, I mean, they're focused on 4 companies, right? And they pick a market cap on a date certain, likely, right? Not on in the future, if TikTok rose to be this size, they too would be, no. It's like, if you're not at, now, it's not going to apply to you. And I think that there are really, as you get into the details and the weeds of some of these bills, I would hope maybe there's some changes to them. There's some inquiries, stronger inquiries about what they're really doing. Some of the ability to give a private right of action to foreign state-owned enterprises to get discovery against US tech platforms, I think should be worrisome. I hope there would be more careful examination of those kinds of proposals. So, I hope that if a bill other than the one for resources goes forward, it would be in a much changed version than what we've seen thus far.
All right. Well, thank you all very much, panel. I've learned a lot from talking with you. And thank you to the audience. I hope that we make some sort of a positive impact here. That's why we're all doing these things. And a special thank you to the AEI team that makes all this possible. It's wonderful to be able to talk with bright, intelligent people and talk about interesting topics, but nothing happens without the team that puts this all together. So I'm grateful for that. So thank you all for being here. And we look forward to talking with you again sometime soon on whatever is an important issue.